My name is Nick Cohenmeyer. I'm a California licensed attorney, and today I'm going to talk about the just cause provisions under AB 1482, which is California Assembly Bill 1482, which takes effect January 1st, 2020. Under AB 1482, which California Governor Gavin Newsom signed in October of 2019, rent caps and just cause eviction will be state law when AB 1482 goes into effect January 1st, 2020. If you're a landlord for a single-family home, condominium, or multifamily home that is 15 years old or newer, your property is likely exempt from the provisions of AB 1482. So what I'm going to talk about today will not apply to you. Now, even if you are covered by AB 1482 under that criteria, there still might be other exemptions, which I will mention some of them today. So owner-occupied properties are exempt where the landlord shares bathroom or kitchen facilities with the tenant, as well as single-family owner-occupied residences in which the tenant rents or leases 1 to 2 units from the landlord, who is also an occupant on that property lot. To keep this video brief, I will only discuss the just cause eviction mandates under AB 1482. I'm not going to talk about the 5% rent cap. That's another video. So what does just cause mean? Under AB 1482, just cause means that a landlord is prohibited from terminating a month-to-month tenancy or foregoing the renewal of a fixed-term lease without providing a reason for the termination. And the reason the landlord gives must be a permissible reason under the law for termination. The new just cause provisions of AB 1482 only go into effect after the first 12 months of the tenancy. Before then, just cause does not apply, and the landlord's ability to evict in a non-rent control jurisdiction without giving a reason remains unchanged from current law. If the current tenant has been there for 24 months, that's right, 2 years, or less, keep in mind 2 years or less, because this is important, and that tenant decides to add an additional tenant to the lease, then just cause will apply if all tenants have continuously unlawfully occupied the unit for 12 months or more, or one of the tenants in the unit has continuously occupied the unit for 24 months or more. So that's why I emphasize 24 months or less, because if the tenant has been there for 24 months or more, any tenant in that property, it has to be on the same lease or rental agreement, then all of the tenants on that lease or property agreement will be covered by just cause, assuming the property is not otherwise exempt under any exemptions under AB 1482. So there's two categories of just cause under AB 1482. The first one is at-fault just cause. The second category is no-fault just cause. So here are some examples of at-fault just cause. Unlawful use of premises, default in the payment of rent, a breach in a material term or provision of the lease, criminal activity by the tenant on property and common areas, or threats off the property directed at the owner or agent of that property. Tenant's refusal to deliver possession of the unit after providing an owner written notice of intention to terminate lease, which owner has accepted in writing. If the tenant creates a nuisance on the property, failure by an employee tenant to vacate after termination of employee if that tenancy was tied up with the tenant's employment with that owner. Unlawful assignment or sublease by tenant. Committing waste on the property. Refusal to allow owner to make authorized entry onto the property. So those are the categories of at-fault just cause. Now under no-fault just cause, the landlord is attempting to get the tenant out, but not claiming that the tenant did anything wrong. So here's some examples of no-fault just cause. And keep in mind, you might have to pay a relocation fee to your tenant under no-fault just cause, which I will talk about in a moment. So under no-fault just cause, one of the reasons why a landlord might want to invoke no-fault just cause would be the intent to occupy the unit by the owner or the owner's spouse, domestic partner, children, grandkids, parents or grandkids, or grandparents. Now, this is important. After January 1st, 2020, if you intend to utilize this provision of intent to occupy, then you have to have the tenant's consent in writing, or you have to have that language in your lease before July 1st, 2020. So even if you don't think you're ever going to occupy one of your units or have any of your immediate family, such as your grandparents, grandkids, sister, etc., occupy that unit, it's not a bad idea to have a provision in your lease reserving your right as a landlord to utilize this provision of no fault just cause. Otherwise, you have to get the tenant's consent in writing, which isn't impossible, but it could be difficult. So avoid the headache, put the language in your lease starting now. 2, withdrawal of the residential property from the rental market. So if you, the landlord, want to withdraw your property from the rental market, that would be considered no fault just cause, but you're probably going to have to pay a relocation payment to the tenant, which I'll discuss in a moment. 3, an order by a government agency, court, or local ordinance to vacate the property due to a habitability issue concerning the property. And that can't be a habitability issue that arises from the tenant's own doing or negligence, which I'll talk about in a moment. 4, lastly, an intent to demolish or substantially remodel the residential property. So what does substantially remodel mean? Well, it's not vague in any way. It's specifically defined under AB 1482. And under AB 1482, substantially remodel means to replace or substantially modify any structural, electrical, plumbing, or mechanical system that requires a permit from a government agency, or the abatement of hazardous materials such as lead-based paint, mold, or asbestos, which cannot be reasonably accomplished with the tenant in place because it requires the tenant to vacate the property for at least 30 days. Now I'm going to talk about relocation payments under AB 1482. And again, these only apply under no fault, just cause eviction. So under no fault, just cause, if the landlord wants to remove the tenant, the landlord has to provide a relocation payment to the tenant in one of the following manners. Make a direct payment to the tenant equal to 1 month of the tenant's rent in the amount based on the date of the notice that the notice was issued, or waive the tenant's final payment of rent for the final month of the tenancy prior to it becoming due, which has to be in writing. So again, there's 2 types of relocation payment that the tenant, not the landlord, can choose. First option is you make a payment to the tenant in the amount that that final month's rent payment would have been based on the date the notice of termination was issued, or you waive the tenant's final payment of rent for the final month of the tenancy prior to it becoming due, but that has to be in writing. So keep in mind that you, the owner, must notify your tenant of her right to choose between option 1 or option 2. You can't decide for the tenant, it's the tenant's choice. And if the tenant chooses option 2, then you have to state the amount of rent that you're waiving in your writing, and that no rent shall be due for the final month. In writing, emphasize in writing. If you don't do it in writing, it comes down to he said or the tenant said, and it's codified into state law anyway. So make sure any correspondence with your tenant that has any substance, meaning could be used as part of your evidence when you have to show that you followed all protocols. Make it easier on yourself. Do it in writing. Email, at least. You could do a text, but do it in email or a letter. All right, so there's a couple of exceptions to when you, the landlord, might have to make a relocation payment under no fault, just cause. So the first is if the tenant is at fault for the condition that triggered the need for the tenant to vacate, then this would really no longer be considered a no fault, just cause eviction. So the landlord would no longer be obligated to provide a relocation payment to the tenant. Furthermore, if the tenant fails to vacate after the expiration of the no fault notice to terminate, and any payments were provided to the tenant, then those payments can be recovered by the owner in an unlawful detainer action to recover possession. Lastly, there's a sunset date to AB 1482. On paper, at least, the sunset date is 10 years from now, January 1st, 2030. Obviously, nobody can make any accurate predictions whether this will actually sunset on that time frame or not. I have a feeling AB 1482 is going to be very popular by the tenants. So my name is Nick Cohenmeyer. I'm a California licensed attorney. If you have questions as a landlord, then feel free to reach out to me. I hope you found this video useful, and if there's any other topics that you'd like me to discuss, please let me know and I'll work on them for you. Thank you.